At trial, is there a difference between someone telling an intentional lie versus an unintentional lie? You want to know the answer? Come join me for a walk at the beach as I share with you the answers to those questions. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, yes, there is. Someone who tells an unintentional lie may be someone who simply forgot the answer at the moment they were asked when they were testifying. So for example, somebody on the witness stand says, "Hey, Mrs. Jones, what date was it that you remember going to this particular doctor's office visit?" And now she says, "Oh, I went on January 7th. Now, the hospital record or the doctor's office record reveals, no, she didn't go on January 7th. She went on January 23rd. Is that an intentional lie? In all likelihood, the answer is no. She gains no benefit from giving an inaccurate description or an answer to when she went to the doctor's office. And especially if this happened years afterwards. In other words, she's testifying years after this event has already occurred. The fact that she doesn't remember the exact date from years prior, is that going to make a difference to her credibility? In all likelihood, the answer is no, it's not. So now let's turn that around and say I'm questioning a doctor in a medical malpractice case. And now I ask the doctor to explain a particular note that he wrote following a patient's office visit. And instead of giving me a standard response, he gives me something that is entirely favorable to the doctor and may be contradictory and may have contradicted something that can be found elsewhere, let's say in an insurance record or in the patient's own testimony, or maybe even in the extreme case where the patient somehow recorded that conversation with the doctor during that particular office visit. And whether or not that's admissible is a different story and a different question altogether. But for the purposes of this video, the question is, if a person intentionally lies, is that different? And do we treat that differently than somebody who is unintentionally giving something that they remember happening, which may not actually be accurate? The answer is absolutely. If we find out that someone has intentionally lied, now we can attack them totally differently. If it turns out that the witness intentionally lies and now has a motive, an intentional motive to lie because they know that if they give the correct answer, it's going to hurt them and hurt their case. Now, at the time of closing arguments, we can approach this argument and we can approach this particular lie, and now we can show to the jury how this lie affects this witness's credibility. And there are many different ways to do that. Some people think that when someone lies, you should call them out on it right away. You should make it so obvious, it should be so clear that the entire courtroom, the entire jury, the judge, everybody in that courtroom knows that this witness has lied. On the other hand, there are different strategies if somebody lies intentionally. One strategy is you get the person to commit to that lie. And now you ask them repeatedly, are you sure that's your answer? Is that something that you specifically remember occurring? And now by digging in their heels and saying, yes, that is the answer, this is absolutely the answer. And now this witness gets off the witness stand without you blowing it up and shoving it in their face. And now what happens next? What happens next is that you wait for the appropriate time to introduce and to show to the jury that this witness is an intentional liar. How do you do that? There are many different ways. Let's say there is testimony that this witness gave in the past that contradicts the testimony that they just gave. Now I have the ability to read that pre-trial testimony to the jury, to show them that this witness is less than credible, to show them that this witness had different information to give to them than he gave a year or two earlier when he was asked the same exact question. On the other hand, there is an alternative strategy to this one, and there are multiple strategies to calling somebody out as a liar. One of them is to simply move on. I can use another witness to try and show that this particular statement is incorrect and that the person who made it is a liar. You know, I also have a question for you. If I'm able to determine and able to show that a witness at trial is an actual liar, do I have to call them out, or should I call them out and call them a liar to their face? Should I go ahead and say, you are a stinking no good son of a gun liar? The answer is there are some attorneys who believe, yes, that's appropriate. On the other hand, there's another strategy. I could now wait in ambush, wait until closing arguments at the very end of the case, And now I can point out to the jury the inconsistencies that this witness created and explain and show to the jury how the testimony that he gave a year earlier is remarkably different than what he told the jury at the time that he was at trial testifying in front of the judge and in front of the jury. And now, the next question that I asked was, is it acceptable or should I be calling this person out and calling him a liar? Mr. Jones was an absolute liar. Dr. Gonzalez was an absolute liar. Is that necessary? Many people, myself included, think, no, that's not necessary. Now, why is that? Because I often want the jury to reach a conclusion about that particular credibility, that witness's credibility, all on their own. When I point out the significant inconsistencies between what this witness has testified to, do you really think I need to say to the jury, this guy told an untruth, something that's not true? This guy said something that was fabricated? This guy is really an absolute piece of crap liar? Do you think I really need to do that? Well, there are some times where it's called for, and many other times where it's not. I want the jury to reach that conclusion on their own, because when they reach that conclusion all by themselves, without me physically and emotionally showing it to them, you know what happens then? Now, their convictions, their perceptions, their beliefs tend to be much stronger. Why? Because they have determined this answer on their own about who is more credible than not. And no matter what else you know about these types of civil cases that occur in New York, whether it's a medical malpractice case, an accident case, or a wrongful death case, you should know this, and that is credibility is the most important thing in any particular lawsuit, any particular civil lawsuit in New York. If your credibility is shot, if you had said something that's untrue, and now you've been called out, now your credibility comes into question. And at the very end of the case, after the attorneys have made their closing arguments, the judge is going to give the jury a very special legal instruction. And that instruction is called falsus in uno. That's a fancy Latin phrase that basically says, okay, jury, if you find that a witness has testified falsely about one thing, you have the right to disregard all of that witness's testimony or some of that witness's testimony. But the fact is, you have the ability to disregard everything this witness has said. Why? Because now you have determined that this witness has lied. And in that instance, that is a very, very powerful jury instruction. So let's get back to the questions that I raised at the very beginning of this video. If someone has testified unintentionally about something that is inaccurate or untrue, do we treat that the same exact way? The answer is no. That's excusable. Nobody's going to make them out to be a liar if somebody doesn't remember a particular date or what they were wearing or what they had for breakfast or what they saw that particular morning, because those facts and those errors in remembering those things are really not significant. But where, however, a witness has testified falsely and we can show it and we can prove it and we can establish that this witness is an intentional liar and has a motive and has an ulterior motive, because he knows that if he tells the truth, it will affect and directly impact the outcome of his case. In that instance, it's going to make a huge difference how we approach that particular witness, how we attack that particular lie, and how we address the jury on thinking about what this witness has said to them to try and convince them that his testimony was correct. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this video because you wanted to see the beautiful beach. No, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.